My name is Matt Berger. I'm a partner with the European law firm of Field Fisher, and I'm based in Hamburg, Germany. I'm the organizer and one of the speakers of our program, The Power of PI. PI stands for Preliminary Injunction. So we will tell you something about litigation in the trademark context, not only regarding the US, but internationally. We will be touching upon the EU, Latin America, and China.
Hello, my name is Kenya Gramblin. I'm a law student at University of New Hampshire, Franklin Pierce School of Law. I will be a law student reporter at the 2022 ABA-IPL Section Annual Meeting, IPLSPRING. I hope to see you in Washington, D.C., April 5th through 7th. What is one of the biggest roadblocks or challenges when litigating trademark infringement internationally?
I think there are two things. First, choosing the right venue, which is sometimes complicated in multi-jurisdictional disputes, to find really the right spot where you get the best result, obviously. But there are always cost considerations. And the second part is intertwined with that, which is enforcement, because it's nice to have a judgment at the end of the day. But if you cannot enforce it, or the costs are so high that it doesn't make any sense for you to enforce your judgment, then the client will not be happy. So I think those 2 points are really important in this context.
Are there any countries that do not recognize US trademarks or are notoriously harder to litigate in?
First of all, I think besides the US, no other country will be recognizing US trademarks, because trademark rights are territorial. So if you want to enforce your rights, you have to have trademark registrations, usually in the specific country where you want to litigate in. It may be that a home registration in the US could play an important role, for instance, in cases regarding bad faith. So if another party already knew about your US registration and is then filing a trademark application in another country, that might help you. But usually it's territorial, so you have your trademark in the country where you litigate in. And I think there are always countries where it is harder to litigate in, for instance, where it is really costly. Like in the US or the UK, other countries are more cost efficient and have very quick procedures, like the German courts, for instance. Other courts are, well, infamous for handling of IP cases, and I don't mention the countries here. It really depends on the case if you will be successful at the end.
Hello, everyone. My name is Ili. I'm a law student at Boston University, and I also work on campus at the Office of Technology Transfer right now. I will be a law student reporter at 2022 ABA-IPL Section Annual Meeting, that is IPLSPRING. I look forward to seeing you there, and let's chat later. Germany is famous for its trade fairs, and the German courts are known for their quick response to preliminary injunctions. Do you have any advice for companies exhibiting in Germany?
Actually, I'm representing a client from the toy industry, and we always have the biggest trade fair for toys in Nuremberg, Germany, every year. And what we always do, we prepare really for this trade fair. We prepare drafts for preliminary injunctions. We gather evidence of the client's own rights before we even go there. We scan the catalog of participants at the trade fair. So, because we already know sometimes which companies exhibiting there will be potential infringers. So we prepare this, and then we'll later on visit their booths and check the booths for potential counterfeit products. There will be bailiffs on the ground at the trade fair. There will also be the customs authority will have a presence there, usually at the biggest trade fairs in Germany. So they will be helping. It's always helpful to have applications for the later enforcement of court titles, for instance, at hand as well. So there are many things which you can prepare to before you attend such trade fairs.
A cease and desist letter may trigger the infringer to file a declaratory judgment, which leaves them the opportunity to pick the time and venue of the action. Any suggestion to avoid such problems for your client?
Yeah, it really depends on the jurisdiction where you're in. Sometimes it's advisable not to send a cease and desist letter, but to hit hard first with a court action, and then you can still negotiate with the defendant. But for instance, in Germany, it's more or less mandatory to send a cease and desist letter before you file an application for a preliminary injunction. Otherwise, the court will not go ahead with your proceeding. So, and other countries will have specific rules for that as well. So you really have to take that case by case and discuss with local counsel if you even have to send such letter, if it's mandatory or if it's advisable not to. There are exceptions. For instance, if an infringement is really imminent, for instance, the next day you already know there will be infringement be happening and you have to stop that, then courts will make exceptions even in Germany. So yeah, depends on the case.
Hello, my name is Taylor Dubell, and I'm a law student at Western New England University School of Law. Prior to my time at Western New England, I got my master's degree in fashion law from Fordham University School of Law, where I primarily focused my studies on intellectual property. I will be a law student reporter at the 2022 ABA-IPL Section Annual Meeting, IPLSPRING. I look forward to seeing you all there. How often do infringement actions end at a cease and desist?
I would say the majority of cases, of trademark infringement cases, never go to court. The cease and desist letter, a well-crafted cease and desist letter, if you really have a strong claim, almost, not almost always, but I would say at least in 80% of the cases ends there. Most of the time it's possible to find an agreement with the infringer. So it's not all about litigating in trademark cases.
What happens when there is use of linguistically or phonetically similar words or phrases in another language?
So that's an interesting question. And again, as always, it depends on your case. I can give you an example. For instance, in the EU, it depends, since we have a lot of languages in all those member states, it depends in which country you are, how well the targeted audience understands foreign languages. And what kind of language it is. I think in most countries, easy English words will be understood by the average consumer. But if those are words which are not from the everyday language or are words from more exotic languages, then there will not be any likelihood of confusion, because of course it has to be understood by the consumer that there is some kind of different, similar meaning or even identical meaning. But there have been decisions in many member states that trademarks which are in one language and infringing words which are in a different language, but if those are identical or at least really, really similar, those can be held confusingly similar, so that there would be a trademark infringement.
Hi, everyone. My name is Christina Yana Crosdale, and I'm a 2L JD MBA candidate at Howard University School of Law. As the world becomes even more globalized and brands begin to find their ways into various markets, how will such expansion complicate litigation with regards to trademark infringement claims? Will there be a need for amendments on an international level with the proliferation and rapid increase of trademark applications?
Yeah, what we have seen with the rise of the internet specifically, it becomes more and more difficult to protect the trademark internationally, because there are so many markets where an infringement can happen. And trademark owners, of course, have only a certain budget to defend their trademarks. Even larger companies, which are active in many markets of the world, have to choose where they really go after infringers and where they don't. Plus, there are certain other difficulties. I can give you an example of the General Data Protection Regulation, GDPR, and in the EU has led to the consequence that whois information of internet domain names are not accessible anymore usually. So it's really hard to find out who the owner of a website is where, for instance, counterfeit products are sold. So there need to be, I think, solutions on an international level that make it possible again for trademark owners to protect their trademark rights and enforce their trademark rights more easily. And I think also on the enforcement level, it would be really helpful to have more international treaties and possibilities to enforce a court title which you have got in one country, to enforce it cost efficiently in another country. Because what happens sometimes is that you have such judgment, but it's already clear that the other party, which is at the end of the world, another country, will never take notice of the court title or will never answer to that. And it's even more costly to enforce the judgment, for instance, in another state than what you could get out of it for damages or reimbursement of costs. So there are many, many, many problems with international trademark litigation, which are complicated by the new commercial realities nowadays.
Hello, my name is Elena Harris. I am a law student at Howard University School of Law. I'll be a law student reporter at the 2022 ABA-IPL Section Annual Meeting, IPLSPRING, and I look forward to meeting some of you there. Are certain countries more bullish than others with regard to IP enforcement? What enforcement mechanisms do these countries tend to take?
Yeah, I think, of course, there are differences. There are countries like the US or the UK or Germany where it is really, where the court systems are working efficiently, where you can easily defend your IP rights, including trademarks, where the enforcement works pretty well. But as it is in other countries, and it's not only in the so-called undeveloped world, but there are many, many other countries as well, where it takes a long time to litigate, where it is really burdensome to enforce judgments, where it is costly to enforce judgments. It really depends in which country you are in, and sometimes there are possibilities to choose your venue. And it's always a wise choice, of course, then to choose a venue where litigation and enforcement is most cost efficient.
My name is Daphne Epe, and I am a law student at the American University Washington College of Law. I will be a law student reporter at the 2022 American Bar Association IP Law Section Annual Meeting, IPLSPRING. I hope you join us at the conference in Washington, D.C. How relevant is a preliminary injunction in international trademark disputes?
I think in multi-jurisdictional disputes, a preliminary injunction, which you can obtain in, for instance, one venue, can be really, really helpful and a powerful tool, because you can show the infringer, which is infringing your trademark in different jurisdictions, that at least in one country, a court has already allowed the claim, and that most of the time, or in many cases, leads to a swift settlement of the disputes in the other jurisdictions as well, because the infringer has to fear that you will also successfully enforce your claims in other courts. So what we sometimes do in practice is to choose the best venue where we think that we most easily get a judgment which is enforceable also in other jurisdictions, and then put more pressure on the infringing party and try to come to a settlement which covers all jurisdictions where the infringement has happened.
ADR versus litigation, which is more efficient for international trademark disputes?
To be honest, I'm dealing with trademark litigation now since almost 20 years, and I have never been involved in an ADR case in trademark disputes, except for domain name disputes. So I think ADR can be a very helpful tool, but my feeling and my experience is that it is almost never used in a trademark context. Which is, I think, a shame. That it could help many trademark owners to enforce their trademark rights sometimes more quickly and also more cost efficiently. But the reality, how I'm perceiving it, is that litigation is still the tool that most trademark owners are using in an international context. And I hope that ADR will be used more in the future.